Hey there, everyone. Welcome to Dementia Care Source. Some of the most challenging parts of caring for someone with dementia are when that person with dementia is no longer able to make decisions for themselves. And right now, I want to talk specifically about end-of-life decisions. Decisions made by the person must be made with sound mind, which is an ever-closing window for someone with dementia. One thing I see over and over again with families is when things like this are put off until the end of the disease, and by then it's often too late. You're in such a state of grief that you can't think clearly, much less have that person with dementia be able to guide you in any way. So tonight for Dementia Care Source, we're going to be doing an interview with an attorney who is going to be talking to us about the legal aspects of end-of-life planning. And we are going to be talking about the 3 documents that everyone should have. So if you're concerned about impairment, get these documents in place before the dementia and the grief that comes with it reduces you and your loved one's ability to make these decisions. So with that, I'm going to hand it over to Adam Smith.
All right, thank you, Gina. So yeah, you brought up a very good point. As capacity is diminished, you get into a very murky area of the law that is, you can remedy that by getting a conservatorship or a guardianship over the person, and you're able to make some certain decisions that way. Things you can't do will be drafting their will or performing anything like that for settlement of their estate. So it is very important, no matter what your age, that you go ahead and you get these documents in place. Keep them updated, make sure your family is aware of where they can get them, record them at the courthouse, leave them with your lawyer. There's any number of ways that you can do it. But those 3 documents are a living will, also called an advance directive, power of attorney, and of course your will. Now, the first one, the living will, probably the one that as a healthcare provider you're the most familiar with, is one that lays out your wishes for everything pertaining to care should you not be able to make decisions for yourself. This is a document that doesn't require to be notarized. Oftentimes you can download it from the internet. Each state has a particular one suited specifically to that state. I recommend people go that route rather than trying to form something off of LegalZoom that's more complicated, that doctors and nurses aren't used to seeing. So if you can get the form for your state and have it filled out, give it to your primary physician, let your family know your wishes. That's very important. Most of these documents have a clause at the end of them that allows your healthcare proxy, whoever you designate to make decisions on your behalf, to override anything that is in that document if they believe that's the case. You can grant them that right. It's very important to have that done, because it does alleviate a lot of guilt on the side of the family, because they're having to make decisions possibly to terminate care and making end-of-life decisions that they're going to ask themselves for the rest of their lives, did we make the right choice? Is that what they would have wanted? So important to communicate that and have it in writing. And so,
as far as people with dementia, a lot of that is the feeding tubes, right? Because the end of stage for dementia is loss of ability to feed yourself and eat and swallow safely. So that's a big one I see, as far as wondering what mom, dad, grandma, grandpa would have wanted, so. Right. Such a big relief when you know.
Yes. Yeah. And when you're filling out that document, I really encourage people to talk to a healthcare provider, because there's a lot of things with those questions that you may or may not know. The fact that being on a feeding tube for an extended period of time, what does that do to your digestive system? Being on fluids for an extended period of time, what does that do? So you want to go into this having made an informed decision, and clearly understanding what it is. It's important to talk to somebody who knows that. I'm that person. So that would be something you'd want to have that conversation for sure. The next document we discussed was a power of attorney. This is an important one to have, and there are many kinds. There's your basic power of attorney, which if you draft it, I encourage you to number one, speak with a lawyer in your state and find out what the state laws are there. Far too many people go to LegalZoom and those types of things, and they may not get accurate documentation, and when it comes time to use it, it's no good. And if the person is in a situation where they are in diminished capacity, don't have the legal capacity to redraft another document, they're kind of dead in the water, and you're left to go to try and get the guardianship we talked about before. So there is durable powers of attorney that you could draft. For instance, if I was going to be out of the country and I needed you to sit in for me to execute a real estate transaction, I could fill out a limited power of attorney that just gave you the right to do that on my behalf. Another option is the full-blown power of attorney, which essentially gives a trusted member of your family, friend, whomever, the right to act on your behalf. Basically, in a legal sense, they are you. They would have to present that document. You know, it has to be, usually in most cases, if they were opening a bank account, a brokerage account, whatever the case may be, it needs to be reviewed by that company's legal department. They'll have to sign an affidavit that it is still in effect and valid. But that's where you want to be careful with who you designate as your power of attorney, because you are giving them the right, the binding right, to do everything on your behalf. And so that leads to a topic that is important to discuss, and that's elder financial abuse. And unfortunately, this is a pretty grim statistic.
I see this all the time.
Yeah, it's rampant. And the reality is close to 60% of financial abuse is committed by a family member. The next 16 to 17% is committed by friends and neighbors, with the remaining portion being done by a home healthcare worker. So, you know, that's an entirely another topic. We may want to talk about it sometime. Things to look out for if you are a family member who is concerned that there may be some undue influence on the person that you care about that is in this diminished state of capacity. So definitely something to be aware of there. The final document, and this is the big one, is your will. And unfortunately, this is the one that people put off for ungodly amounts of time. I can't even tell you, I know people in their 70s and their 80s that don't have their wills. But what they don't know is they do have a will. And this is the way that it works from a legal perspective, is if you die and you do not have a will drafted, you have died in a state of intestacy. Okay, that means you died without a will. What most people don't realize is your state has a will for you. You're not going to like it, most likely. It's not going to distribute your assets in the way that you want it done, but it's in the books. And usually what happens is half will go to your surviving spouse, the other half will go to your surviving children or their next of kin, and so on and so forth. But it's really important to get this drafted, get it down. Again, tell your family where it is, communicate what's in it if you feel comfortable doing that. That way, you know, you can, let everyone know what to expect. Mm-hmm. And it's also a very important tool to use in estate planning, how your estate's going to be distributed. Because there's a variety of methods that can be used, from trusts, both revocable, irrevocable, testamentary trusts, and just a lot of things that can be done there. But the will is going to give you the opportunity to pass property, specific property, what they call specific bequests, be it sums of money, grandpa's shotgun, whatever the case may be, that you want to go to a certain person, and you get that put in writing. And also real estate and other things like that. Then you can set up testamentary trusts within the will, for example, that would allow you, the trust essentially does not come into effect until you die. So then the estate could fund that, and then the provisions of the trust can carry forward for multiple generations. So it gives you a lot more flexibility if you want to like fund grandchildren's educations or set up some sort of a legacy, that type of thing. But one thing that I've seen quite a bit is I've rewritten more wills than I've just straight out written. And the reason for that is too often people will go into an attorney's office, and not that the attorney is trying to railroad them or anything like that. They're just trying to get this buttoned up and done. And they throw a lot of legal terms at them. They don't understand them. But when the document is actually reviewed, it doesn't do what that person wanted them to do. There could be little nuances in there where a lawyer would put the term per capita, when in actuality what you want is per stirpes. And it's not important to get into this to the nitty gritty of all that, but the idea being is if you're leaving money to your children, but one of those children isn't alive at the time of your passing, what do you want to happen to that portion of the money? And that's where the per capita, per stirpes comes in. Per capita would mean that gift would terminate, everything goes to the surviving child. Well, what if there are grandchildren from this child? Do you want to not leave anything to the grandchildren, or do you want that child's share split equally among those grandchildren? So it's really important when you go into the attorney's office to understand, number one, what you have. That's one of the legal requirements for executing a will, is to know who you are, who your family is, what you own, and then follow it through. How do you want your assets to be distributed? And then if you can communicate that properly to the attorney, they should be able to draw up the document to do what it is that you want to do. There's certain instances that you can't do what you may want to do. One that we run into quite a bit is a rule called the rule against perpetuities. Anyone who's been through law school hates this rule. It's a little tricky one that says that any bequest would have to vest in the person that you're leaving it to within 2 years of life and being. That's horrible.
Oh gosh.
But
Say that one more time.
Yeah, it means that the gift must vest in the person that you leave it to within 21 years of a life and being. So if I was leaving money to my grandchildren, okay, but after I draft the will, or maybe at the time of my death, one of my children becomes pregnant, and I've set the will up to where the money doesn't vest in the right amount of time, the rule could be, or the will could be deemed invalid. So it's kind of tricky. I may not have given you the best example there, but there's just things like that you need to realize. And that's why it's good to just go ahead and pay the money and have a qualified attorney draft it, because if you get into these self-help sites, you can get yourself into some real trouble, and you're dead when this thing is executed. So there's nothing you can do really to remedy it. So you want to be sure that everything is tight. It can't be, contested or anything like that. Yeah. So again, get it done as early as you can. While you still have the capacity, you want to be sure that, again, you communicate with your family as much as you feel comfortable doing so, because that goes back to the elder financial abuse. Because a will can be contested if the family believes that there was undue influence by a home health care worker, for example. When you pass away, they get the will. and for some reason half of your estate is left to your home health care worker. Strange. And so, you know, it could be contested. It starts getting into a whole mess that you just don't want to go down that road. So a trust can also operate as a will substitute. So it doesn't have to go through probate. So a lot of people use that because, you know, they can, particularly you see that, obviously you've heard trust fund babies, but that's going to be a tool that a lot of people use because when a will is probated, it becomes public record. So anybody could go down to the courthouse, start going through the will books, pull up the will, and you know, see all your dirty laundry and that type of thing.
Yeah.
And when I was in law school, I think I told you the story. In my wills class, one of the things that one of the wills we read was where one of the parents had disowned one of their children, and the reason for that was, you know why. We love that because everybody wanted to know why. But yeah, so that type of thing would be, you know, a public book at the courthouse that anybody can get. So a lot of people do use trusts. They're a little more complicated, certainly more expensive to administer, but that is a valid option to do. But the testamentary trusts, as I said, those are built into a will, and it just lays out, you know, ways for the money to be handled. So I'll give you an example. If husband and wife have essentially what we call I love you wills, which means if I die, everything goes to you. If you die, everything comes to me. But we have, I'm trying to wait my monitor up there, sorry. We have a thing that I like to put in wills. It's really important. It's called a common death provision. So sometimes called a simultaneous death provision. What that means is we're a married couple, we have kids, and you know, again, if something happens to me, everything goes to you. Something happens to you, everything comes to me. But our plane goes down. We're in it, and it's impossible to determine who died first, whose will control. So there could be situations, I've written wills for people where there have been instances where stepchildren are involved, okay? Let's say person A has a biological child and two stepchildren. The other person could have a couple of biological children, however the case may go. And each person is concerned that if they die and their money goes to the other person, that somewhere down the road they could disown, or not disown, but disinherit the stepchildren, and those children of the deceased biological parent would never receive the assets that they had intended them to receive. So what they'll do is they will build into the trust or into the will a testamentary trust. And you can make your life insurance policies, your 401ks, any of your assets pour into that trust upon your death, and then those funds are administered by the provisions of that trust. So the surviving spouse, most oftentimes there'll be a clause in there that says that, you know, the money is to be used for their education, healthcare, you know, on and on and on. And they can lay out, they can exhaust the trust if they want to, or, you know, a certain sum has to be left for this child or the other. One thing that I saw recently in a will that I had to redo was the attorney who drafted it was concerned about that situation. And so they'd written the will such that upon the passing of the first parent, money would be given to the children at that time. I think it was 25%, it's not important, but then the remainder of the money would go to the surviving spouse. And so a little problem there, going back to our nursing home situation, is long-term care is expensive. And, there are ways to write these wills such that you're caring for your surviving spouse and you can still make sure that the kids get the money. There's ways to do. So again, when you go in, be clear of how you want your assets to be distributed. Listen to the attorney, ask questions, listen some more, ask more questions. This is what you're paying them for. So be sure that the document at the end is what you want it to be, does what you want it to do.
Mm-hmm. Yeah. So now my brain's thinking, worst case scenario. Well, there's always more worse scenario, but let's say that there's a gentleman, a husband in the nursing home, end stage dementia, clearly not able to make any decisions for himself. And they're wanting to put him on hospice, end of life is present, and there's no will. And so now the wife, the survivor, is looking for what her options are, let's say in a week. Let's say she, in her mind, thinks she has a week to look at, is there anything you can do at that last minute window there?
Well, your choices are pretty limited, but again, there are things that are set up, particularly when you buy a home, for instance. Mm-hmm. Generally, the way that home is titled is what we call joint tenants with rights to survivorship. Okay, and what that means is the husband and the wife, or whomever is buying this house together, both own the home equally in entirety, and at the passing of one spouse, full ownership goes to the other spouse. Okay, that is often the case with joint bank accounts, any number of things. The problems that you run into is where something is titled just in the name of the one spouse that is going downhill, unfortunately. And there's the only way is to go through the court. You're going to approach it very much in the same way that you would a will. You're going to have to submit to probate that the person died without a will, in which case the court will appoint an executor, personal representative, whatever your state calls it, and then lay out how assets will be distributed. Unfortunately, again, it may not be what was intended, so it can get sticky.
Yeah. So not surprising at all. It sounds like you're not going to get through the courts in a week.
No.
This is, yeah.
No. Now, it's also depending what it is that you're trying to achieve in that week. Certainly, you can get emergency orders granted if you need, to be appointed as a guardian, a conservator, whatever the case may be. That can be done if choices need to be made on that person's behalf. But in terms of, again, assets and those types of things, those aren't considered emergencies in the eyes of the court.
Gotcha.
That is the biggie there. So and I know I threw a lot at you, so I'll pause, see if you have any questions that you want to ask about that.
Yeah, I definitely like the thought as far as preserving the legacy, because I think, trying to talk to families about this, it can be hard and awkward as far as saying, conversations about that person dying, and trying to prepare them for something that none of us are ever prepared to talk about ever. So I think that's a great way to approach that person that you're trying to make these plans, is to talk about preserving your legacy. I think that's a very nuanced way to put that. So I'm going to remember that one. And then talking about, making sure that you get a good attorney. What are some, thinking specifically about legal issues with end of life care and estate planning? Are there any certain qualifications that if someone's looking for an attorney, they should look for or ask if they have experience in?
Oh, absolutely. Absolutely. It's the same as, if you were going to see a specialist or anyone like that, don't be shy to ask the question, is this your area of the law? I don't want a tax attorney writing my will. They're great at taxes. They may not be great at, this type of work. There's also, it doesn't need to be a one-stop shop. You'll want to bring in a lot of people, financial advisors, family members, everyone to create your estate plan. And particularly the more complicated the estates can be, because again, there's a lot of things that can be done, from gifting while you're alive to reduce the amount of your estate if you're in the fortunate group that might be faced with an estate tax at the end. It's really in your interests while you're alive to reduce your estate below that threshold, or else the government's going to get half when it's done. So, and it's a moving target. They adjust it for inflation and things like that. So, definitely something to consider.
Mm-hmm. Yeah. I'm practicing right now in rural Kentucky, and that's the biggest thing is farmland. It's not people with a ton of money, but they might have, a 300, 500 acre farm that's been in their family for generations. And then suddenly grandpa gets dementia, has a stroke, whatever, ends up in the nursing home. And then, it always moves quicker than you're able to kind of plan for. So.
Yeah. And, that wasn't on the list of topics, but you just sparked something in my mind that I think is important to talk about. And that is in planning. It's very important to take into consideration your funeral. Now, you want to talk about a topic people don't like talking about. That's probably at the top of the list. But here's the reality that people need to realize is when you pass away, if you have all of these documents in place, wonderful. Your power of attorney is not valid after you pass away. Now, there is a clause within a durable power of attorney that says that it is deemed valid if whether or not it's known if you're alive or dead. So the person on the other side of the table can act in good faith and accept that document. But remember what I told you before is the person delivering the document has to sign an affidavit saying that they know that this is good, it's in full effect. So if you pass away, your power of attorney knows it and tries to use the power of attorney to do something, they violated the law. So why did I tell you that? It's because to pay for your funeral, people have to have access to money. Mm-hmm. And there's a variety of ways that you can do this. You could have a child as a joint account owner on your bank account, for example. That's an option. But again, you have to have enough money in that bank account to pay for the funeral.
Very expensive.
Very expensive. I mean, when you're talking about casket, vault, opening, closing, funeral services, all that stuff, you can get to $20,000 very quickly. And if the money isn't accessible from your funds, your family has to foot the bill. Funeral home's not going to do this on credit.
Yeah.
So that's something that's really important. And another pre-planning thing that you might want to do is just go ahead and pay for these expenses up front. Again, let your family know. Have a folder, a lockbox, safe deposit box, whatever the case may be where this stuff is stored. and have a trusted family member that has access to and can get to them when the time comes. So I just wanted to be sure to bring that up, because that's not a good position for the family to find themselves in.
Yeah, because best I remember just from, having lost people in my family, it can take a while to get a hold of the bank account, the checking account. I mean,
Right.
Like months.
Because you have to take the will, assuming there is one. It has to be probated, but you have to have the death certificate first. That could take a week, 2 weeks, whatever the case may be. It's going to take at least 30 days generally for even the simplest will to be probated, and the court will issue what's called letters of testamentary, which says it pretty much appoints the executor of the estate. And that letter, that court order, gives that person the power to begin to execute the will as it's laid out. So it can take a while. So the next topic that we might want to talk about would be planning for incapacity. Okay, so a lot of people
with dementia, yeah,
inevitable, and people don't like the thought of nursing homes, and the cost is extremely high and continuing to go up. So there are a few ways, to pay for this. Two, obviously, there's long-term care, which, depending on your age, it just like life insurance gets ever more expensive the older you get, and the more, I'm not sure if comorbidities is the right word in this instance, that you have that might predispose you to needing one of these facilities in the future. That is one option. The companies that issue these types of policies are few and far between. There was a big push about a decade ago, maybe more, time flies, but a lot of companies were issuing these. And then they found out that they were paying out more than they were getting in, and it's drawn quite a bit. Now, according to state law, speaking specifically for Alabama, you have to, a company has to get permission to increase rates on a class of individuals. So everybody's rates would have to go up. I've seen it go up 25% in a year, just so they're breaking even. And after a while, it just gets to be where it's just not affordable anymore, so people will drop it. Fewer people that are insured, the less money that's in the pool. So the insurance company gets in a tighter and tighter situation, so you can see which road that goes down. Now, a lot of people are concerned, for instance, if you have a spouse who is in perfect health, you have to go into a nursing home, and you don't have sufficient assets to pay for the care. What happens? Okay. So the way that the government works, Medicaid will pay for nursing home care. I should caution you that it is not the best care that you would receive if you paid for it on your own. But you have to be destitute in their definition. Now, in the state of you being by yourself, they would take everything, and then they would begin to pay. Different states, different laws, but generally in a married situation, they would take half of the assets. They would leave one car for the spouse, let them stay in the house for their lifetime, after which, it gets liquidated and paid for. So there are some strategies that you can get around where you can shelter some assets, but you need to be aware that Medicaid has what's called a look-back provision. What that means is that I could write a revocable trust for you today. You could put your farm, your home, you transfer the deed for all of it over to the trust, and you have to go to a nursing home 2 years from now, well, it's still feasible by the government because it hasn't been 5 years. So that's another reason to get started early, to start thinking about these things. And particularly when you get into trust, there's a lot of legal nuances that can be kind of tricky. If you retain control of the money in the trust and you can make decisions and all of that, it doesn't give you some of the same protections that it would from an estate planning purpose as if you did a irrevocable trust, where you surrender all of it and you have a trustee managing it who has full independence. So that's one.
Yeah, I don't think we've talked about this yet, but as far as the process of becoming a power of attorney, that would be, I know we recommend it to have it set up, but I don't think I know a lot about how that process starts.
Yeah, well, okay, yeah, so the process of, setting up a power of attorney is pretty straightforward. The form is not overly complicated. Most cases, those that I draft, 2-3 pages long, it basically lays out who the person is that you're granting power of attorney to, and then there's a laundry list of powers that you give that person. Okay. And a lot of those powers are codified in state law. So, you list them out, for purposes of if I was to use this power of attorney out of state, for instance, we want to be sure that they understand what powers that you've given someone and what powers you're withholding. You may not want a person to be able to do certain things. But once that form is signed and notarized, then you'll give that copy to the other person. And a lot of times the form will have a clause saying something to the effect of a copy is as good as the original. So you can make copies of it to where you can have that. The important thing to remember with that is if you down the road change your mind, you need to get that form back. You need to destroy it and notify the person that they are no longer the power of attorney. So then there are other interesting ones, one called the springing power of attorney. Now this is one that might be of particular interest to you. And this is where I would say, okay, Gina, you're my power of attorney if it is determined that I no longer have the capability to make decisions on my own behalf. So until that decision is made to by a court, you have no power, because you would have to have sort of a lock and a key. You have to have that document and the court order establishing my incompetence. Together, they give you the power to do what you need to do. And those can be very effective, but I've run into situations, particularly in financial institutions, where they can be a little tricky. There's certainly nothing from a legal standpoint that would prevent you from using it if you had all the documentation. It's just some of the smaller financial institutions don't have a robust enough legal department to actually analyze those documents and make a determination that, yes, these are valid, and you can proceed. So if you do go that route, it's probably better to go to one of the bigger financial institutions if you're needing to transact some business or something like that. Save yourself some headaches.
Yeah, that's a scenario that as a speech pathologist I'm involved in quite a bit as far as determining if someone is of sound mind. It's always, multidisciplinary approach depending on their comorbidities and, what else going on. But definitely always highly recommend having especially someone with dementia, having a speech pathologist input, because we kind of look at the stuff that sometimes is left out as far as, is this person able to hear the questions? Are these is there just a simple communication barrier as far as them being able to understand and express what they really want? And it's kind of surprising how often that is able to resolve the issue, but focusing on people with dementia, you know, as that progresses, the waters just get muddier and muddier, and it's more difficult than people think, I think, to determine that someone is not of sound mind.
Yeah, I mean, you just taught me something. I never would have thought to have involved a speech pathologist in that. So
yes, and just like an attorney, you want, you know, a speech pathologist that's something that they're familiar with and they've done before. But yeah, definitely someone you want a part of that team. So we've talked a lot tonight as far as, you know, getting an attorney, talking to your attorney, finding an attorney you trust, and ways to do that. But what are maybe some other situations that you've seen as far as the end of life process when having an attorney present would be recommended?
One of the things that I've seen is, unfortunately, a lot of times when someone passes away, there is a lot of conflict within the family. So having, you know, an attorney draft the will, have been in full conversation with the person who's drafted it, that can really advocate for the will, can downplay a lot of conflict. And again, there's the communication we talked about beforehand, that's important. Yeah, there's situations where some people, you know, may contest the will and things like that. So again, it's just very important that it's executed properly and would survive any legal challenge. So this is certainly not a DIY project you want to take on.
Yeah, not to pick on LegalZoom, but that last was the perfect reason as far as having a relationship with a attorney, with a legal professional that you can go to throughout the process. Because, you know, something like with dementia can last for years. It can last for over a decade. So, you know, things are going to change. But either way, I think both of us would definitely advocate for not waiting that point in life. I know that's kind of the demographic in the group that I mostly want to speak to, but for all of us in our 30s, 40s, 50s, everywhere in between, that it's something you want to go ahead and get started now.
And the reality of the situation is that as you age, your financial situation is going to change. Your family composition is going to change. So please don't consider these static documents. It's really important to revisit them and, you know, to look at them in the light of your current situation. You may want to update some things. That can be done a variety of ways. It doesn't have to be an expensive, full-blown redraft of a will. The attorney could simply draw up something that's called a codicil. And all it is, if it helps you think about it in terms of a constitutional amendment, we're not totally redrafting the Constitution, we're just fixing this one little part. And it becomes incorporated into the will. And yeah, that can be done relatively inexpensively. It's not a heavy lift at all.
Yeah. Very cool. Well, we covered a lot, so we'll take a pause here, but we will be seeing you again soon. Thank you so much.
Thank you.